Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about a really interesting topic, and that's secret use of patents. As most people know, when you file a patent, to get a granted patent, it has to be novel and inventive at the time you file it. Now, there is another carve-out that's slightly different, and it says that you cannot have secretly used the invention before the filing date or before the priority date. Now, what secretly used in this context means is that you can't have made money out of the invention. I can't have gone off and filed a patent for something that's still secret, although I'm selling it. And a good example is, say, Coca-Cola's secret recipe. Coca-Cola can't now file a patent for that, even though it's a secret recipe and no one really knows what it is. The reason being is that under Section 18 of the Patents Act, there's actually a prohibition for secretly using things before the priority date. And the really interesting thing is how secret use plays into software development. Because software development, quite often, when you make MVP or a minimum viable product of your software, it's quite difficult because you usually have to release an alpha and a beta version of it. You have to get it tested. There's a level of experimentation, and often with beta versions, you can be charging a client for it, even though it's not a full version, and the client is more working on the development side with you and they're giving you stuff back that's more than just the cash value of the contract. Technically speaking, would that be secret use or not? And under the Patents Act in Australia, if you're experimenting or it's used for a reasonable level of experimentation and trial, then it's okay. It's not regarded as secret use under the Patents Act, and that wouldn't qualify. It would be secret use if it was for a commercial purpose. Now, the problem is with software is sometimes there is a bit of a commercial purpose and a bit of a trial usage. There's never been a case on it in Australia on that particular point, but I think it's important to realize the motivation behind the secret use provision is whether it's for experimentation, particularly if the client's not paying the retail fee for the product, it's a reduced price. You're not really charging a commercial rate for the product, which to me would indicate that it's still secret use. The other thing to bear in mind also with secret use is that in Australia and overseas, in some countries like USA, there is a 12-month grace period for filing patents. So if you accidentally disclose your invention, you can file the patent after the disclosure. The problem is there's a few if, buts and maybes with that, and you have to be very careful and talk to a patent attorney before you think about using grace periods for filing. They're potentially dangerous, and potentially you might not be able to file rights overseas. And also there's a few caveats to it in the fact that you have to file a complete application and not a provisional. I hope this helps you understand a little bit about secret use. It's a fascinating topic, and it's interesting how it interplays with software. If you have any queries about secretly using your invention before the priority date, please feel free to contact myself or the team at Alder IP, and we're more than happy to help. Thanks for listening.